So we will reconvene. And Shelley, I understand you wanted to respond before we ask any further questions. So over to you.
Thank you. I just wanted to go back through clause 3.16 of the NPSIB if I could. So if you could bring it up, if you have that somewhere in your documents, and you could bring it up, that might be helpful just to have it all in front of us.
So what we'll do, Cliff and I will share a screen and the other two will share a screen. So yes, we have 3.16 in front of us.
Thank you. So this clause sits within the NPS in the part marked implementation. So there's a lot of implementation detail for the NPSIB, and that predominantly relates initially to significant natural areas, which has quite a substantial process for it. And then what we've been submitting is that 3.16 sits there as a catch-all provision for where SNAs haven't been identified. So that's in the heading Indigenous Biodiversity outside SNAs. And in my submission, that's a recognition by the drafters that there were going to be interim periods and interim processes where Indigenous biodiversity would need to be managed, where that Indigenous biodiversity had not been identified as an SNA.
Can I just ask you to take your foot off the accelerator of speed just a little bit, please? I know it sounds as though you're very excited and want to get it all out, but we need to catch up with you.
Sorry, no, I talk too fast. It is a perennial problem. Apologies. So clause 1, this is our effects management hierarchy, which we've looked at and which has been incorporated in the provisions that have been provided in draft for the panel. Clause 2, so clause 1 is the effects management hierarchy. I don't think there's any magic to it, but it needs to be recognised. Clause 2, for me, is an interpretation, is a construction, a drafting construction, which directs the incorporation of the objective and policies of the NPS and requires them to be applied with any process that is referred to in subclause 3. So it is a method in my submission, of requiring the application of the objective and policies to all Indigenous biodiversity outside SNAs and requiring a local authority through subclause 3 to be consistent with the requirements of 3.6 for all other Indigenous biodiversity. So it's what you would have probably done anyway if you'd gone straight to the objective and the policies, but this is the way that in 2 and 3 it requires local authorities to apply those for all Indigenous biodiversity outside SNAs. The effects management hierarchy is supplementary to that, and that's recognising in my submission the fact that from the date the NPSIB came into effect, it wanted the effects management hierarchy to be taken account of through these processes also. So then we have a requirement to observe the objective and policies of the NPS and the effects management hierarchy in developing the plan provisions, which in my submission the council team has done, and Mr. Heal has addressed that in his March supplementary evidence again, for example, at paragraph 13 onwards. Once that you've got that policy, national policy framework, you of course then have the regional policy framework which supplements that, and unless it is inconsistent, then you can just go ahead and apply the objective and policies of the
So I think you're right that my focus in questioning was one, and the significant adverse effects threshold test, which is the one that DOC were most concerned about. What I'm interested in is if we are, through the rule framework, achieving protection because we are having no more than minor effects, or using minor as the threshold, and some avoidance, those two, as opposed to significant adverse effects, which I think we all understand are different to no more than minor. How can you guide us in terms of case law around protect as it relates to avoid and no more than minor effects? Can you help us there? Because that is the thrust of why I was honing in on all of this, is the significant adverse effects test in 3161, to me, did not sit comfortably with protect in the way that I've understood protect tests to apply through case law. And what I've heard in that exchange with Ms Perkins is, and from the expert evidence we've received from Mr Wells, I think, that we are talking about no more than minor adverse effects, perhaps, rather than significant adverse effects, and avoidance. And is that a more appropriate alignment with the term protect in the case law?
So is this in relation to a rule for new activities or for
Yes.
ongoing for new activities? What new activities are you contemplating? Can you point me to a particular part of the rule that you're looking at?
I think lots of what we've been talking about are the exceptions being applied in the Hokonui Hills area to do with the fencing limits. That's been the focus of DOC's attention, and probably why we're having these conversations. It's the outstanding point of contention, if you like, or one of them. So the idea as to whether those that approach has been the right approach, and much of that seemed to hinge on whether or not the boundary line for the clearance limit was significant adverse effects.
Can I just...
I would observe that an existing boundary line is not a new activity though.
Oh, sorry, what I mean by boundary line isn't a physical boundary line, sorry. I mean like the test. Yeah, so the thrust of my question was if there's any assistance that can be given to help us align the word protect with an appropriate threshold, might be the better word that I'm looking for. So there's significant adverse effects as one threshold. No more than minor adverse effects, as I understand it from case law, is a different threshold. And that's a different threshold again from avoid. Is that basic summary, that avoid, no more than minor adverse effects, and significant adverse effects are different thresholds in the law?
Matt, have you got your finger on the button there?
Yeah, before we get there, I just want to tease out where DOC's coming from, because what we've largely done is we've had, since DOC's submissions, we've provided further evidence, which is effectively in relation to the Hokonui Hills area, acknowledging that in order to ensure effects are no more than minor, we have included provisions in J and K which avoid threatened and at-risk species and rocky habitats in J, same in K, but we've extended that to the land management area, because those are the particular areas that DOC were concerned about.
Yep.
So I understand where you're coming from, but I'm just not sure. I think we've responded to what Doc, the issues that Doc is raising, is my point.
And so what I'm trying to get at, because I understand the outcome that you've reached, what I'm trying to get very, very clear about is the foundation for our decision making that we are relying on to establish that no more than minor adverse effects is the appropriate threshold when you're trying to protect something. And that avoid is the appropriate threshold, or those two things in combination are the appropriate threshold when you're trying to protect something, and that those two thresholds are different from a threshold of significant adverse effects.
So I think we're talking about the application of the use of that term in a rule, and just need to differentiate it from a resource consent process, where we are familiar with applying that separately. And my understanding of what Mr. Hills just observed is that the evidence is that no more than minor effects would occur as a result of that, of the amendment that's been made.
Which amendment are you talking about?
So this is to J and K, because Commissioner Bartlett was specifically focused on Hokonui Hills in Rule 2. So in Rule 2, 1J, we've added, previously we had vegetation clearance in areas A and B, as shown in Appendix 7, is permitted if it avoids threatened and at-risk species, and we've added and rocky habitats.
In the land management area.
We've added that to K because the land management area is in Area C.
And so obviously DOC have still left on the table the complete removal, and the reason for that is that they don't think the right test has been applied.
Sorry, the complete removal of...
The rule. My
okay.
understanding is that their position is that, you know, that they're actually leaning towards removal of...
My understanding is that their particular concern was about the land management area, and we've said nothing's permitted if you're in the land management area in Rule K. So we're talking about the construction of new fences in particular in K. And we're saying you can't do that if you're in the land management area or a rocky habitat, because those were the two areas they were particularly concerned about. So I think we have addressed what they've raised, because you can't do any new fencing in those areas. Sure, you can do all the other activities, because that's because the NPSIB anticipates that you can do those activities, and the RPS gives very little guidance because it's a high-level document and it doesn't go into that level of detail. So that's how we've landed where we've landed. We have applied the no more than minor test through the ecological advice.
And that's been really important, because I think DOC were reading the ecological advice as using a significant adverse effects threshold test. So I'm just going to check again with Mr. Wells. Is it a significant adverse effects threshold that you were using, or a no more than minor adverse effects threshold in your analysis?
We were looking for a no more than minor. Just to comment, if we'd been looking applying a significant adverse effect standard, we could have suggested much greater clearance levels. That's just an add-on to, make it clear that.
No, that's important. That's very important what you've just said. Quite significant. Like, I don't want to use that word; it's overused. But that is a very important statement in terms of our considerations. Yes.
Mr. Wells, I'm not sure if you're the guy to answer this. Perhaps it's something that Brett could have answered, but I get the impression, and you've been up there on these rocky outcrops and ridges, that basically from a farm management point of view, they're of little value. They're avoided. Your observation?
In terms of the rocky habitat, definitely, yeah, because you can't get machinery or up there, and also the stock don't like it, as just forgotten Brett's surname, but as Brett was informing us. So yeah, the rocky areas are not obviously high value for farming.
Can I just go back to the NPS IB and the policy framework? And I'm just trying, because they guide the way that 316 is looked at as well. There probably only appears to be two policies in the whole list that's there that are relevant to what we're looking at. And policy 1 talks about relationship of tying to the Treaty of Waitangi. Policy 2 is tangata whenua values, which are referred to and relevant in any case. But policy 3, a precautionary approach, is adopted when considering adverse effects on Indigenous biodiversity. So we do, that's a tick in terms of something that needs to be front of mind. Policy 4, Indigenous biodiversity is managed to promote resilience to the effects of climate change, which I'm doubtful is a relevant consideration for us at this stage. Policy 5, it talks about being in an integrated way, so that's more at a regional level. Policy 6 is talking about SNAs, 7 SNAs. Policy 8, importance of maintaining, so the verb there is maintaining Indigenous biodiversity outside SNAs is recognised and provided for, so that's the second one to have regard to. Policy 9 talks about certain established activities are provided for outside of SNAs, and not too sure what that then leads to. Policy 10 is recognising that social, economic, cultural, environmental wellbeing recognised. 11, geothermal SNAs. 12 talks about plantation forestry, and the rules recognise that. 13, restoration of Indigenous biodiversity is promoted, so that's more a policy framework for the plan an action rather than a rule. 14, increased biodiversity cover is promoted, so again it's not a rule by itself. Policy 15, areas outside SNAs that support the highly mobile fauna, and that's recognised in the policies that we can't do anything on that until the regional policy statement picks it up. Policy 16, regional biodiversity strategies, isn't relevant, and monitoring. So of those policies, the only ones that need to be front of mind to us is policy 3, which is a precautionary approach, is adopted, and the second one that talked about areas, 8. So 3 and 8 would appear to be the only two policies that are relevant to us.
9, because that provides for certain existing activities. So that's why the permitted activity list in the rule effectively reflects what's in the NPSIB provisions.
Okay. So that's probably helping my understanding of the link back to the NPS.
And then the one thing I would observe there is that the language in policy 8, the importance of maintaining
Yeah.
outside SNAs, has its corollary in policy bio point 4 of the RPS, which is maintaining things that are not significant versus protecting things that are.
So, Mr. Wells, I'm having trouble understanding, speaking about the fencing, what these areas that have, without a site visit, don't know, so I'm relying on your judgment. Is there much natural biodiversity in those areas, along with gorse? Like, is it shrubland? Because if stock are eating things, they nibble off all the canopy trees, and the only things that remain probably are pittosporums and coprosmas and those shrubby types of native trees. How much land do you call minor as a loss for natural biodiversity? Is there a lot in these areas to be fenced off, or it is very minor?
I think I understand what you're asking. But so you're asking in the potential areas where fence lines may go,
Yes.
do they have indigenous biodiversity?
Yes.
Yeah, yes, since they do. And so that's, some of them are within SEVA or EVA areas. Yes. And in terms of your question about cattle nibbling or whatever, that depends on the vegetation type. So the vegetation type maps, which E3 Scientific did for Stony Creek and I did for Wantwood, they describe the characteristic vegetation within each of those vegetation types. And so they vary greatly depending on the stage of succession and all the rest. So you don't just have, in some of those areas, you don't just have Coprosma or Pittosporum, you may have Olearia, for example, in one patch that was mapped in Stony Creek. And in other areas, for example, EVA, you'll have very much lower indigenous biodiversity. Is that what you were trying to get at? I might have misunderstood your question.
So it might be useful to reflect on what we were talking about at the last hearing too, and look at the objectives of the MPSIB, which are to maintain indigenous biodiversity, at least achieving no overall loss in indigenous biodiversity, protecting and restoring indigenous biodiversity as necessary to achieve overall maintenance of indigenous biodiversity. And so at the last hearing we talked about no net loss, and actually that doesn't mean you can't clear anything. And the evidence that we've had from the ecologists is they've looked at the limits in J and K and said, in their opinion, that will not result in a net loss, because you're looking at biodiversity as a wider area. So you're taking the macro view, not the micro, what might be, that doesn't mean you can't clear a bush. That means you've got to ensure that those biodiversity values are generally maintained. And so, those limits in J and K, the ecologists are saying that we think those limits are appropriate. Those limits were established by having a discussion with the landowners in Stony Creek and Wantwood, trying to understand what their future fencing requirements are. And we heard earlier today that they wanted more. The ecologists said, no, we think you can have this, because the effects will be no more than minor, and that will achieve an overall, that won't achieve a net loss. So that's kind of how we got to those numbers in the rule. Yeah.
So if you increase the stock limits, which they have spoken about, does that still mean there is no net loss? Because depending on the intensity of how they're going to farm them and how many cows they're going to put in the area, depends on how much.
So that I guess that comes down to how the rules work, because we kind of broached this discussion last time as well when we were talking about mob stocking and the definition, and how the definition talks about any loss or damage, regardless of how you do it. If you exceed those limits, you're going to require a resource consent, or if you're doing clearance, which might be as a result of stock, okay. If you've got stock in the well, you can't have stock in the ridgeline areas, etc., and impacting on threatened and at-risk species if that's going to result in clearance.
So who checks that?
So, again, that we talked a little bit about this last time in terms of monitoring and enforcement, and you know, it's reactive enforcement in effect. If someone complains, we'll go out and look at it. However, we do have to do state of the environment monitoring, so every 5 years. So we've got a map of the area. If we map it again in 5 years' time and we see, oh, there's a whole lot of vegetation that's been cleared somehow, then you can take enforcement action because they haven't complied with the rules, unless they've had a resource consent to do that. So that's kind of how it all knits together, I think.
In policy 9, you referred me to the words certain established activities and said it's in Appendix 4, I think you said. Where do I find those certain established activities list?
You mean in the district plan or in the NPSIB?
The NPSIB clause 9 or policy 9 refers to these. So where do I find them?
So there's a number of clauses in the NPSIB which are specifically focused on SNAs. I think it's 311, for example. So 310 tells you the following adverse effects relating to new subdivision use or development must be avoided. And then 311 is exceptions to 310, okay? So this provides for things like construction of upgrade of specified infrastructure, mineral extraction, functional operational need of certain things, etc. You've got Forests Act provision in clause 4, and I don't know if you can recall, but at the first hearing I provided that table which was colourful, and it said here's the permitted list of permitted activities and the rules, and these are the parts of the NPSIB that they come from.
Okay, but before you move on, what you said was that the exemptions or the certain established activities is what led to the list in the district plan.
The policy, certain activities, then feeds into the provisions in the NPSIB which spell out which things you should be enabled to do.
Yeah.
That list then led into the permitted activity list.
Right, so in what you've just referred to, I don't see any reference to fences, vehicle tracks, roads. You could say there's critical infrastructure, but not walkways, fire breaks, dams, waterway crossings and network utilities.
Yes, so those are, that relates to lawfully established existing activities relating to those things.
So that's not the same as policy 9, which is the way I've interpreted what you said.
Well, this is the guidance from the MPSIB. What's come in through the permitted standards is also by looking at the threshold of more than minor effects. And so the ecologists are saying that it's appropriate to allow for those existing activities without creating more than minor adverse effects.
Okay, so I'm not going to see a direct link through the upper level documents. It's the assessment that have been done by the ecologists.
Yes.
Okay, that's cool. I was just looking for something then that wasn't there.
I just want to check the table that I put together for the last hearing, because that's got the genesis of where those provisions
Last
come
hearing,
from.
hearing 11.
No, hearing 10. The last hearing on this matter.
We'll come back to that. Ask me a moment. Just so, what are you looking at there?
Oh, so this is the table that was tabled at the hearing stream 10 hearing, which...
Is it got an appendix letter?
No, it was tabled at the
Oh,
at the
okay,
hearing.
so it's not on the online
I
material.
think it's on the website for hearing stream 10. Okay, so if we look, so 315, and I'm talking about the MPSIB, 315 talks about managing adverse effects of established activities on SNAs. For the purpose of this clause, established activities means any activity, including maintenance, operation or upgrade, that is in or affects an SNA, is not a new subdivision, use or development. Local authorities must include objectives, policies and methods in their statements to enable specified established activities or specified types of established activities to continue with these effects of the activity on the SNA.
I doubt Shelley can hear you.
Yeah, so have a look at 315, clause 1 and 2, and that, in this table, that connects to providing for the maintenance, repair, replacement or upgrade of existing lawfully established fences, vehicle tracks, roads, etc. So the MPSIB is saying you need to provide for the maintenance, operation and upgrade of established activities.
In SNAs.
Yes, that's right. Yeah.
And 3.17 also provides for maintenance of improved pasture in SNAs. So if there is, that policy is for within and outside SNAs. So you have to sort of read it down in some cases and then read it up for SNAs.
Okay, any other questions relating to the NPS?
Oh. I was wondering about ECO P13 and its enable a range of activities. You're talking about activities associated Indigenous vegetation clearance that recognises the scale of farming operations, the different levels of significance of Indigenous vegetation and landowner conservation practices in the Hokonui Hill area. What does that actually mean?
So in my, it's really just recognising that a lot more work has gone into identifying the values in the Hokonui Hills area, and there was some question at the last hearing about whether that policy should be more directive and actually articulate what those values are. And in my April, I think it was April or March submissions, what I was saying is I don't think we need to do that, so I'd recommended adding at the end of the overview, so on page 2, you'll see in purple specific provisions have been included in the eco chapter relating to Indigenous vegetation within the Hokonui Hills area to recognise the scale of farming operations, etc., etc. Further guidance is available at Gore District Council for Wantwood Station and Stony Creek Station, including a detailed assessment against the terrestrial provisions of Appendix 3 of the Southland Regional Policy Statement. And so in my latest evidence at Appendix B, we've attached these FAQs, which were what went out when the plan was notified, but in the back of there's all these additions which show detailed mapping on in the Hokonui Hills area, including the vegetation types on Wantwood and Stony Creek. It shows the ridge lines that we talked about earlier, and it also goes through and identifies in detail the assessment that's come from assessment against the RPS, and it also includes the information that's come from DOC on the 127 hectares. So effectively what it's saying, that policy is saying we need to recognise those values and the scale of the farm and all that sort of thing. And these FAQs, which will be available on the website if people want to come and get a resource consent in the future, articulates what those values are in detail. So it's a way of capturing all the evidence that has been presented and making sure that we've got it available in the future so that if a resource consent application comes in, people can clearly see what the values are and that sort of thing.
Okay.
So that policy means that if they did want to do an activity there, they would need a resource consent?
No, what that policy is doing is it's kind of a framework for the rules that we've drafted specifically for the Hokonui Hills, and then those FAQs will help articulate what the values are.
Thank you.
So I think we've finished questioning in terms of the national policy statement. I'd like to then move on to the regional policy statement, just to ensure that we've got a common framework that we're moving forward to, and then looking at the plan provisions. And so looking at Chapter 6 of the regional policy statement, and Objective 1 talks about understanding and identify, which was more process. Objective Bio 2 talks about maintain and protect. So it says maintain Indigenous biodiversity in Southland and protect areas of significant Indigenous vegetation and significant habitats of Indigenous fauna for future generations. So the directive has come up there that we are to protect significant Indigenous vegetation areas.
That's correct.
Right. Which then leads us on to and it links to section 6C, and Objective Bio 3 is talking about an enhancement. So at the policies, Policy 1 refers to identification of significant areas and says to identify them using the following. One is a schedule of threatened, at-risk and rare habitat types. 2, ecological assessments undertaken by a suitably qualified person using the criteria in Appendix 3, and the criteria listed in Appendix 3 include the following, so that's more information. And D, in collaboration with land owners. Now, the work that has been done in terms of identifying the SEVA and EVA, the evidence we have is that those areas have at least one of the significance criteria that's listed in Appendix 3.
Is that correct, Andrew?
Now, given that it has not been done in collaboration with landowners, what is the significance that we can then rely on any work that is undertaken to identify these areas?
So there's a few things in that.
Okay, move it closer. So,
Yeah, so a few things in that. Obviously, we have been working in conjunction with Stony Creek and Wanwood Station, so there's no issue there. In terms of all the other areas, you might recall from the 42A report, there was a bit of background in terms of we established a working group which had a number of stakeholders, including Federated Farmers and Forest and Bird, etc. And then we were in the process of going out to talk to landowners, and the council decided that we shouldn't do that because the NPSIB was changing, so we paused that, and so we haven't had that opportunity to go and talk to landowners at this stage.
some funding was available from ES that gave the opportunity of landowners saying, come and look at my land.
That's correct.
And that has happened
For some sites.
For some sites.
Yeah.
And we don't know what the outcome of those investigations were. And do those areas that are identified as meeting the significance test have a higher degree of reliability and hence a higher status, theoretically, to areas that haven't been dealt with landowners?
I might just defer to Andrew in terms of whether the information that was garnered or was garnered from site visits through ES has been used in any way to map the CEVAs and EVAs, well, CEVAs principally, that we have in the plan, and then I'll have a look at the RPS.
So the properties in Gore District which have been surveyed under ES's scheme have all been surveyed this year pretty much, and most of the survey reports have been completed and are with ES. Some are still in completion and are not yet with ES. I am uncertain what has happened beyond that, which would be, my understanding is that they are available to the District Council, but I'm not sure how that process works once the reports are received by Environment Southland and the landowners. But in theory, the idea is that they will then flow on through to identify these areas in the appropriate process. And then to answer your other question, once that is done, yes, they would have a different status than the current, desktop mapping.
Okay, now, picking up on the national policy statement, it talks about a precautionary approach. And so does the regional policy statement talk about a precautionary approach. Is the way that the identification of the CEVA and EVA through the wider district and showing them on a map a reflection of a precautionary approach?
It is, in terms of the way the mapping, the desktop mapping was undertaken. So there's, even in desktop mapping, there's a degree of expert judgment which comes in when you're deciding, is that exotic gorse or is that shrubland? And the approach that Wildlands took in that was, if in doubt, take a precautionary approach and put it as EVA.
Right.
So that was applied in terms of the desktop mapping.
Sorry,
Yeah.
just to reflect back on what you've just said. So the precautionary approach is from the tabletop mapping that's been done, if an area is identified as having values, then it's EVA. No. If there's doubt about whether an area is indigenous vegetation or exotic vegetation, the reason being, even on aerial imagery, it can be sometimes difficult to be certain.
So in areas where there was doubt, it was put in as indigenous vegetation
Right, so...
rather than exotic. In other
Right.
words, rather than
Yep.
excluding it from the mapping,
Yep.
it was
Yep.
included, which is why the mapping includes a caveat that there will be potential errors in this because areas of exotic vegetation may have been included as EVA.
Right. So what you've identified as SEVA, then you're certain that there's indigenous vegetation. Are you certain that it meets the test of significance?
No, because you cannot be certain of that until you've undertaken a field survey.
Right. So is it a precautionary approach to require protection or management of the SEVA areas across the wider district?
To require protection or management.
Well,
I don't know quite. I don't think it's precautionary to require management. That would be implying you are enhancing or restoring. But I think, yes, there's the, which was the rationale for the rules framework, Eco R1, was that there's the permitted clearances for existing lawfully established activities, and then the very small allocation for additional 50 square metres, and that was in the context of, well, that's as we've discussed with the Hokanuis, that's a level of clearance which will ensure that.
the other thing I just want to explain is that the maps aren't included in the plan, okay? So what's included in the plan, so the entry is indigenous vegetation clearance, that's defined. If you're not meeting the permitted standards for indigenous vegetation clearance, you need a resource consent. That, whether that's a discretionary activity or a non-complying activity, will depend on whether you are in a SEVA or an SNA. That's non-complying. If you're in an EVA, it's a discretionary activity. Those terms are defined. Okay, so they're not the maps are just guidance that sit outside the plan that the council has to help determine whether something might be a SEVA or an EVA. Okay, the definition in the plan is the thing that the plan has. The definition doesn't refer to any maps. It refers to the criteria for establishing whether you're a SEVA or an EVA.
And so in that respect, it would be very similar to the discussion we were having yesterday in terms of the natural hazard mapping. If a definition is included in the plan, what you've just described there is maps that will sit outside and inform a definition in the plan, and we were talking about that very scenario yesterday for similar reasons. For the similar reason being that further site-specific assessment may be required, but people have something to put their hand on.
Probably the difference is that, so whether you're a permitted activity or not is in the eco chapter is determined by the definition of indigenous vegetation clearance, right? Whether you need what the type of resource consent you need will be whether you're a SEVA or an EVA, which is in a map that sits outside, which the map that sits outside the plan helps guide you there. With flooding, the rule talks about a 0.5 AEP as a permitted standard, okay? So whether you're permitted or not relates to the 0.5 AEP. Then there's some maps that cover some of the district that we currently have that you can use for guidance to determine whether help determine whether you're a permitted activity. That's slightly different to the eco chapter because you're not working out whether you're a SEVA or an EVA as the permitted standard. That's just helping you identify which type of consent you might need. So they're slightly different, but generally achieving the same outcome, their guidance.
The only other provision in the RPS...
I think that's
Yeah.
not correct, because when I look at Eco R1, which is outside the Hokanui Hills area, and I'm looking at what I think is the last version of Appendix A from your 3rd of April, and Eco R1L, where the reference is made to being outside it's specifically in relation to commercial forestry, Al, but it does make reference to the inside or outside SNA/SEVA.
Yeah, that's correct. That's probably the exception. And that's driven by the MPSIB.
Yeah. The only other provision in the RPS...
Sorry, just to clarify, that takes you to the definition of SNA and SEVA. And then the maps are used as guidance. Yeah.
But that
Which is
does
similar
correspond
to
to the... Yes,
hazards,
that's kind of
yes.
what I was getting at, yeah.
I'll come back to those definitions again later, but the only remaining provision that's in the RPS that I think is relevant to us is Policy Bio 4, which is maintain Indigenous biodiversity, but that talks about it almost in a global sense rather than a more site-specific context.
Yes, and I think the interesting thing there is it talks about making appropriate provision for lawful maintenance of operation of existing activities. So, and that is in a global sense. So, in theory, that could cover SNAs, which are a subset, or SEVAs, which are a subset of Indigenous biodiversity.
Okay, is there
And
anything
we've
else?
had evidence that protect is a subset of maintain, i.e. that... So I didn't ask this question, but it's been sitting in the background. But that protect is a subset of maintain and is reserved for specific sites. Was the thrust of the Otago RPS analysis and all the king salmon stuff that Doc provided us. So I'm getting all the nods. So therefore, when we read Bio 4, it's the wider umbrella, and when we read Bio 2, it's the specific to things that are significant protection.
That's correct. Yeah.
Yep. So is there anything else arising from the regional policy statement that the panel have got any questions on?
Just from me, follow up to the question you asked me, Commissioner Hovell, around the explanation. And the break, I spoke to Mr. Heel, and he identified that his application of the explanation was on all fours, so he didn't see any reason to depart from that.
Thank you. Maria, anything else on the RPS?
I think we've done everything. I'm just doing a final
Okay.
check.
Come back if there's anything that comes up. What I'm still a little bit confused in my own mind is that significant natural areas and SEVA are considered the same under the plan provisions. When the SEVA outside of the Hokanui Hills area have not been subject to the necessary assessment to give them, in my view, equal standing.
Yes, and this is why I think we discussed this at the last hearing in terms of we've been able to be a bit more bespoke around the Hokanui Hills because we have done a greater level of analysis. And yes, they are both SEVA, so inside the Hokonui Hills or outside. The difference with the Hokonui Hills is that we have engaged with the landowners and we've done more thorough analysis, on-site analysis.
And what appears in some of the evidence is that putting potential SEVA in front of those district-wide ones is seen as an appropriate flag.
I think I addressed this in the original hearing too, but I can't quite remember why I moved away from
Because
that.
I see the need to differentiate where an assessment is done, being called SEVA, from where it hasn't been done, where I recognise that it's potentially SEVA. But the next question is, should the rules be the same for a SEVA and a potential SEVA?
So remember, the rules are triggered by indigenous the definition of indigenous vegetation. The consent category, if you need a consent, is dictated as a non-complying activity if you're doing those works inside an SNA or a SEVA. So it doesn't differentiate between whether it's an SNA, a Hokonui Hills SEVA, or an outside Hokonui Hills SEVA. It's a non-complying activity. So the trigger isn't whether you're in a SEVA or not. The trigger is whether you're clearing indigenous vegetation. And if I look at the definition of SEVA, it means terrestrial indigenous vegetation meeting the criteria outlined in Appendix 3 of the Southland Regional Policy Statement, including those areas identified in Appendix 7, so that's the Hokonui Hills, or as part of a resource consent or biodiversity covenant.
I can understand identified in a resource consent. Well, the resource consent is what's a resource consent? The application or the decision?
So you would apply for a resource consent because you're clearing indigenous vegetation, and you would then, to determine whether you're a non-complying activity or a discretionary activity, you would need to, unless you're relying on the guidance material that sits outside the plan, you would then, if you wanted to dispute, let's say, the guidance material because you thought it wasn't accurate, and that could be fleshed out through that resource consent process.
Right. So I think the word process needs to be added to what you just read out.
Sure.
It's not the resource consent; it's the process. And resource consent process includes subdivision.
Yes. Yep.
Yep.
So when you say process, you were saying, assuming that it may not need a resource consent, but you were approaching it as if...
No, you would need a resource consent because you're doing indigenous vegetation clearance. Whether you need a non-complying resource consent or a discretionary resource consent would be determined in terms of whether you're SNA or not.
And so a non-complying one is a significant area. So you've identified it through the process, it is significant. If the assessment that's done concludes no, it's not significant, then it'll be a discretionary activity. And it hasn't been identified as a significant area through the process.
How do you know?
Until you're in the process, you don't.
Yes.
And that's what comes back, I think, an important point, that the trigger isn't the way that it's shown on a map. The trigger is the process of actually clearing indigenous vegetation. We finally got there.
There will be people out there who aren't aware that they've got a SEVA.
Well, they haven't got a SEVA until there's actually a consent.
Okay.
They've
But-
got indigenous vegetation,
They've got
and,
indigenous.
and if they want to clear that, they've got to go through a consent process, and that will assess its significance.
So
What-
basically, anything that's indigenous vegetation, you can't go anywhere near until you talk to somebody.
Well, that's where, if you look at the rule heading, and it was my next question, it talks about indigenous vegetation clearance and land disturbance.
You mind?
And so that's rule 1. So if I'm taking out an area the size of the space in between these desks, does that trigger a resource consent?
Sorry, if you're clearing indigenous vegetation,
Yeah, about the size of the space in front of us,
yes.
between us, does that require a resource consent?
It depends what it's for. If it's for replacing or upgrading an existing lawfully established fence, no, it's a permitted activity. If it's for any of those things in the list in Rule 1, then no, it doesn't. If it's, you know, go down to M, if it's less than 50 square metres over a 5-year period,
Ah,
no.
so that's the, yeah. Okay, so that minimum area criteria is quite an important one. That over a 50-year period allows a nice little building site to be created. And I'm thinking back to the Otatara area in Invercargill, where you've got a residential area and you're allowed to clear X square metres to put a house in. So this is, I guess, a practical response to the minor things that people want to do, be it to put in some sort of shed or something else.
yeah, if they're not already covered in one of the existing, the big
okay.
list in front of that. I suppose the other thing to note is there's no SNAs or SEVAs or indigenous vegetation as far as I'm aware in the urban area. It's all in the rural area, so which is different to the place you just mentioned.
Otatara.
Yeah.
Okay, I'm going to take a rest. Have you got any other questions?
No.
No.
I'm sorry, but I do have additional questions, but not many left actually in terms of what we've talked about already. I've just highlighted 6, so everyone knows there's an end to this. Okay, right. So you mentioned this before. We haven't really talked about the definitions yet today. So what I've noted is paragraph 26 of your first supplementary, not the second one. So now I've got to get to the right place. It's not that. I've got too many things open now to get back to the right place. Still trying to get to the right bit of evidence. Right, I'm at the right bit of evidence. 21 March, paragraph 26. Yes, okay. So when I was looking at this, it led me to want to ask if the general position we're in is that only 2 existing SNAs from the ODP are SNAs under the MPSIB, and that anything else would have to go through a subsequent Schedule 1 process to be mapped and identified and brought into the plan through the big MPSIB process to be in the same category. Would it be cleaner to either remove B in the SNA definition or say meets the criteria and is mapped and included in the plan? I.e., it seems to me that the avenue for this, it was what I was thinking of. What's B doing, I guess?
think it's probably cleaner just to get rid of B, to be honest, because we don't know what's coming.
So SNA has the same meaning as the National Policy statement and elsewhere in the definitions, we've actually included the words where it says states and includes areas identified SNA1 and SNA2 on the planning maps, full stop.
Yep.
Good point.
Okay, and at your paragraph 27, this is the decision to go, well, as Mr. Wells said, we'd probably better to just point towards the RPS directly and get rid of Appendix 4. So I just wanted from you, what would be the main implications of simply replicating Appendix 3 of the RPS? You know, what's the main implications for us of making that choice?
I don't think there's any major issues. One of the problems is that the RPS refers to, is it wetlands, which is why we talk about terrestrial in the plan. So if you were going to do that, you'd have to take that clause out. I suppose if the RPS changes in the future, then you'll have to do a plan change to update the appendix to align with that. However,
But if there's a RPS update, it's going to have implications through the whole document.
Yeah, well, and the other thing is, you know, there's signals that we won't be having RPSs in the future, given the,
So is it a bit neither here nor there? Like, we could stick with Appendix 4 if the wetlands issue's already been resolved through the notified appendix. Is it kind of neither here nor there because they correlate well?
yes.
Sorry, you made reference to
sorry.
Appendix 4.
Sorry, not the existing Appendix 4. The existing Appendix 4 is, that's in the plan at the moment, is a copy of the MPSIB Appendix 1, not the RPS Appendix 3. So you'd need to get rid of Appendix 4, move the text from RPS Appendix 3 into that. You could call it Appendix 4.
So
again.
the main implication, which was my initial question, the main implication is the difference between the MPSIB and the RPS.
Correct.
And that is what we know is that representative criteria is different between the two. That's what the experts have told us. So that's one implication. That goes, right, okay, yep. Actually, it does raise some issues that occur to me, and one is the it is a higher order instrument, it still exists, it hasn't disappeared yet. Yes, we haven't done all the exercise in it to unearth new SNAs, but the criteria that have been used to identify the SEVAs and the relationship between the RPS criteria and the MPSIB criteria, there's that marginal difference in terms of that representativeness criteria. And is it appropriate for us to not adopt the more recent criteria going forward, like understanding that the SNA exercise itself under the MPSIB has not occurred, but that wouldn't mean that you wouldn't apply the higher order instruments. I do understand why, in that you're imagining that the higher order instrument is about to change and disappear. And is that one of the main reasons here?
Yes, and the mapping requirements for councils has been deferred for 3 years. So the council's not going to do that.
No, I realise, yeah, I realise that. Okay, so it is in anticipation of not just the mapping requirement, but it's in anticipation that the criteria will change. See?
The criteria might change. They might not. We don't know that.
No, and that's what I'm kind of getting at. It's a different question to where or when the mapping might happen. It's a bit of a different question. And so because of where we are at this point, we've got 2 sets of criteria, one of which is more recent and in a higher order instrument. If it was left in the district plan for the meantime as it was, or as it is, presumably there's no great implication there until such time as an MPS changes.
So I guess the way it's been defined is SNA has been defined to refer to the National Policy Statement on Indigenous Biodiversity. SEVA has been defined to refer to the RPS because we have to give effect to the RPS.
Yep. But that's right now.
Yes.
Yep. So the reason that we're having to identify these 2 things differently is because of where we are right now.
Correct.
And
so we're going to have to do something at some point in the
we
future.
will have to do something.
We don't know what it is.
But we don't know what it is. But I guess what I'm getting at is, to me, it's a little bit different to go with, we know that we've got some mapped stuff that he's used the RPS criteria and thresholds that are appropriate in light of the RPS and to some extent the MPS. And that's kind of as far as that goes. But obviously the higher order instrument and its criteria still sit there and signal an exercise to come. So wouldn't that sort of elevate it over a reliance on the RPS in the future process? So I guess that's why I wanted to tease out the implications of changing this appendix. It seemed to me that it might be, at this point in time, just as appropriate to leave the criteria as they are and await any future higher order change.
I think the issue is Andrew hasn't used the MPSIB criteria to identify the SEVA. Okay, he's used the RPS criteria.
And that's okay. And I understand that, and that's different to the exercise that might come, is what I'm trying to get at. So that's definitely the situation we're in, because the exercise that's occurred has occurred as an RPS exercise to identify SEVAs, not an MPS exercise to identify SNAs. But the higher order instrument hasn't evaporated, it hasn't disappeared. The only reason we are leaning so heavily here on the RPS is because the MPS process was not followed. So going forward though, we can't assume at this point in time with the statutory framework that we've got, we can't assume a future reliance on the RPS over the MPS, because that wouldn't seem to be the situation we're in.
No, I think that's going to lead to issues, though, in terms of, I mean, this potentially comes back to the earlier discussion we were having about 316, because that's about areas outside SNAs. These aren't SNAs as defined by the MPSIB.
No, I think you're confusing 2 things
Oh, yeah.
here.
Oh, maybe.
I think there's a process that has happened and a process that is to come. And the criteria, if you want, which doesn't seem necessary to me for us to be including the RPS criteria in this plan if the process that's happened that's brought these maps into being has relied on the RPS criteria, but the MPS exists and will guide at this point in time the next exercise. And so therefore the appendix in the plan is about the next exercise, not the one that just happened.
I think the issue is what happens between now and the next exercise.
If we get higher order instrument change, it's no different to any other situation we've got in front of us where we might end up with an MPS infrastructure, we might end up with an MPS deserts.
Someone wants to clear some Indigenous vegetation in 6 months' time once decisions have come out, assuming they're the same, then someone will be going, okay, I need a resource consent to clear Indigenous vegetation. I need to work out whether it's a non-complying activity because it's a SEVA. What am I going to assess that against? At the moment, the plan says you assess it against the RPS because effectively that's what Andrew has done. And the guidance will help inform whether you're a SEVA or an EVA. If you change the reference now back to old Appendix 4, which reflects the MPSIB, that's not the mapping that's been done.
That's okay, because what you just said to us before was you can either rely on the mapping that's been done, which does not sit inside the plan, it's just information. You can either rely on that or you can go off and do your own assessment. Now, at the point that you go off and do your own assessment, the appropriate thing to do at the moment is to do it under the higher order instrument. It hasn't gone, it's still there.
Two things. One, it appears you have an applicant has a choice, and we can't dictate to the applicant which option they want to take.
I think it's different. I think we can't choose the lower order instrument over the higher order instrument at the moment.
Until, yeah. The other thing is that this is going to be an electronic plan. Appendix 4 will not exist in the electronic plan. It will be a link to that appendix at another site as my pick.
I think that, yeah, I'm not sure about links. Because things change.
Probably taken it as far as we can go. I think the question's been asked.
Can I just also comment though, as soon as you've got any information that has been assessed under either sets of criteria that suggests presence of significance, then you're pretty far along the road. The council holds relevant information then, and it wouldn't be able to turn its back on that for any future process. So I think practically speaking, regardless of what you have there in the appendix for reference, you are getting yourself quite far along the road in terms of a significance assessment. And then I'd have to go back to my favourite point, which is what was notified, what was discussed in submissions, and what was put in through evidence to make sure your appendix is appropriate.
I think that's enough of all of that, and I think we've got enough to make a decision. So, yeah, great.
So that's your 8 questions.
No, I've got 4 more. I can do the little ones before the big one, or we can have the big horrible one and then the little ones. Okay, big horrible one. So at the moment we've got the 2 rules, and they're differentiating the Hokanui Hills from everywhere else. And the place at which things get differentiated is after the permitted activity stage, whether you either shoot off to be a discretionary or a non-complying status. And my question really was, if we should be protecting SNAs and SEVAs because they're the protectee things, and EVAs are already sort of thought of maybe the maintain things rather than the protectee things, shouldn't they be treated differently at the PA stage rather than just at the discretionary non-complying stage? And I think that probably also goes to some of the that we're getting from DOC around protect versus maintain, because the clearance limit is the same, and it's only at the resource consent stage that you start to differentiate between the significant protectee bits and the maintain bits.
I think the key thing to remember is that we're talking 50 square, in Rule 1, we're talking 50 square metres in over 5 years. So, yep, you could make a distinction, potentially, between SEVAs and EVAs at your permitted threshold, but I don't think it's going to make a lot of difference in terms of whether the effects are going to be more than minor or not, regardless of whether you're protecting or maintaining.
In other words, another way to say it might be, because obviously we've got Hokanui Hills limits that are much higher, and one of the reasons is the assessments that have been done by Mr. Wells and Mr. Davies, can't remember which, and so it's more than likely that for an EVA, if you were going to differentiate between the two, you'd end up with a higher permitted vegetation clearance level for an EVA than the 50 square metres. That's probably a Wells question. Is the 50 square metres really thinking about protecting significant things? And if you were only trying to maintain less significant things, would your permitted activity clearance area be higher than the 50?
Before I answer that, I'll just say that the 50 square metres was a very small area, which we, when I say we, I mean Calvin Lloyd, who's Senior Principal Ecologist for Wildlands in Dunedin, and myself discussed, and we both agreed that a very, very small clearance would undoubtedly have such a minor effect on even significant values that we were happy with it. So that was the basis how we arrived at that. Now that didn't directly answer your question, but that leads on to answering it, which is...
Yes,
it does? Okay. Well, so, yeah. So obviously the follow-on from that is that, yes, we were confident that significant values would be protected under that. And I think even though we didn't do the sums, the intuitive thought is that if it was EVA, then more than likely you could get a larger limit. Long way of saying that 50 metres squared was a pretty conservative approach that we took. It's a very small area.
Can I just ask then, so if we're talking about outside of Stony Creek, some of those areas, those SEVA areas, will be much smaller. So in comparison, would you still say 50 square metres if the whole area is like 200 square metres? Or is this just particular to Stony Creek?
No, this is outside of Stony Creek.
So how, like, you would not have large areas of Indigenous biodiversity outside of Stony Creek. So
there are some large areas. They're variable size, and the thing is, it's worked out on a property basis, is the way these things work. So if it was in a residential setting where you had, you know, a whole lot of quarter-acre sections, then yes, I think it would be untenable. But given that most of these blocks are within the rural zone, and the areas of SEVA are actually genuinely relatively sizable, even in the smaller patches that were mapped.
I think from memory, there's a table in the economic analysis that outlines the size of the different areas. So if you want to refer to that when you're thinking about your decision, then you can have a look there.
And I guess also it's just if you start breaking down 50 square metres and thinking about how that might apply in a, you know, a block, it's for farm activities, it's sort of puts it in perspective.
What you've told us as well and is that the EVAs are potential. The answer isn't known. So if there are areas of exotic vegetation, they're allowed to be cleared. The rule doesn't apply to them. It's only if they're removing the indigenous by itself. On the one hand, I'm kind of thinking in the EVA there should be the ability to have more flexibility, but that flexibility comes about by whether it's indigenous vegetation or not. And so the 50 square metres within an EVA area probably is of maybe of more importance than actually 50 square metres in a SEVA area because you're more likely to have smaller clumps of indigenous in the EVA. But that's an observation just in terms of something that we need to think about, and no doubt someone's going to be asking, well, what is a reasonable number to have within the EVA area if we want to increase it? So I'd be interested in your feedback there. But you made mention that Kelvin signed off on 50 metres squared. Now, I just want to be clear, did he sign off on 50 metres squared or 50 square metres? Because one is 2,500 square metres.
No, definitely not that one.
So he signed off on 50 square metres?
Yes.
Yes.
I hadn't even thought that there was an alternative.
No, well, you said
Yes.
50 metres squared.
Oh, okay. I see what you get. Yeah. No, so absolutely not. That was never in our minds.
I have seen in the front of the Environment Court the person say, oh yeah, I was meaning 50 by 50 was reasonable. And everyone interpreted it as 50 square metres or whatever the figure was in that case. So I don't know, did the panel want any guidance in terms of if we are looking at a bigger number in the EVA, you know, what's a reasonable figure to look at, or do you think that 50 is appropriate regardless?
Sorry, I thought you were asking the panel. Like, personally, I was quite happy with the 50. If you were considering going higher, then I don't think I'd be wanting to go terribly much higher. I might probably recommend 50% higher, which would take it to a 75 square metres. But honestly, I think anything more than that, to me, I'd feel like we were starting to get into guessing games and lacking the certainty, which would make me feel that we weren't being suitably precautionary.
Maria, you're up to question 3 then. Did that take care of your big question? I didn't actually think it was a huge question. I thought
it took a lot more brain power than I think the last 3 are going to. So, so Eco P1 was my next question. It was paragraph 31 of that same bit of evidence. So, no, that's all about. No, paragraph 31 appears to be talking not about Eco P1. So I'm just going to go to Eco P1 because that's what my question's about, and I'm looking at your latest version of that.
Might be paragraph 33.
Yeah, maybe. Yeah. Anyway, my question: could you remove reference to SNAs and SEVAs in the chapeau? There is no thing in. Oh, it must be in the chapeau of. Oh, I haven't written my
P1,
Yeah. And then include reference to SEVAs at the end of B by saying including SEVAs and removing the word identify at the start of B.
Sorry, were you looking?
I'm looking at Eco P1.
Yes.
and Eco P12, and taking reference to SNAs and SEVAs out of the SHEPO, so it would go identify all areas of significant Indigenous vegetation or significant habitats of Indigenous fauna. And I think I don't know what the next word would be, to include, I suppose, areas. So going to be, take out the word identify because that's already in the SHEPO, and then start with areas that meet the terrestrial criteria set out in including SEVAs.
Well, you could just refer to SEVAs if you want, without the reference to the Appendix 3 of the RPS, because SEVAs are defined as those areas that meet the criteria in Appendix 3 of the RPS.
Yes, and I think it goes to the heart of our conversation around the appendix before, because then the policy's only telling us things that have already happened. But going forward, depending on the criteria that are applied going forward, you might have to differentiate how other things come in besides.
Sure. So you could just refer to SEVA instead of Appendix 3 of the Southern Regional Policy Statement.
But then we might need a C.
What would the C be?
It would be how areas of significant Indigenous vegetation or diddle-a-doo would be identified going forward. And so if we adopt your suggestion that we ditch Appendix 4 and go with the Appendix 3 criteria going forward, then that has a forward-looking component and including the SEVAs that we just did component.
So if you're looking forward, you don't need 2A because it's already happened.
Yeah, and I guess this policy, this gets to what this policy is doing. This policy is telling us in part what has already happened, but I'm presuming the function of the policy is going to have a forward-looking element to it.
I think as a panel we need to look at the wording of it, and probably it's a matter for us to determine. I think what I'm trying to say is, next question.
Yeah, but you can see the issue that I've raised, yep. And when I was looking at the appendices, I wondered why we don't have an IVA definition. So I've highlighted it as Appendix G, so I must have been looking at Appendix G when this question occurred to me. Yeah, and I wondered if an IVA definition might simply say means terrestrial Indigenous vegetation that does not meet the criteria, whatever criteria is being used now or going forward, or an area that has not been assessed and is not expected to contain significant species or habitats.
I think the reason I didn't include it is because we have a definition of Indigenous vegetation. So it's already kind of defined. There's a definition in the plan of Indigenous vegetation, I think, yep.
Except that an IVA is something that does get referred to, does it not, in the actual, hang on, I'm just going to do a control V.
If it does get referred to, maybe it should just be referring to Indigenous vegetation and not IVA, yeah.
There we go, there's the answer to that, marvellous. Because actually, oh, no, that's all right. Doesn't matter. No, actually, this is a little bit of a doozy. I think I know what the answer is, but I'm going to ask it anyway, and it is my final question. So, would the clearance thresholds, either in Eco R1 or Eco R2, as permitted activities, still be appropriate if the SEVA areas were in fact SNAs under the MPSIB? It's a hypothetical.
I think so, because the criteria are pretty much the same, but I don't know about you, Andrew. So the SNA criteria are pretty much the same as the SEVA criteria. So would the clearance limits be different?
Not from an ecological point of view, but there may be aspects in SNA and the MPSIB which I wouldn't know off the top of my head. It's a slightly roundabout answer, but I hope you know what I mean.
I do. So the answer to that question might be more of a planning answer than an ecological technical answer.
That's certainly the way that I'd see it. I feel like from an ecological point of view, it doesn't change the values that would be there. But because SNA has a particular planning meaning, there may be aspects which probably not, but...
And then that being the technical advice, what do you think the planning answer is to that? If you looked at that same area and ran down the MPSIB response, would you end up in the same place?
Yes.
And that's incorporating the differences that have been applied on the Hokonui Hills.
Yes.
Which I understand brings us to the end of question time.
I have to ask one. If I don't ask this, it's going to keep me awake. Righto, under the RPS we've got SEVAs and EVAs. Under the MPS we've got SNAs. Is there a corresponding category to an EVA in the MPS?
No.
It's so...
So the MPSIB is a general direction about maintaining Indigenous biodiversity. So Indigenous biodiversity is made up of two parts.
Yep.
Indigenous vegetation area, EVA,
Yep.
and a SEVA, right? Significant, yeah. So yes, there is guidance, and it's about you need to maintain all of those things, but you need to protect SEVA or SNAs.
Yep, maintain EVA. But under the MPS you've got SNA, which is all encompassing.
Okay, so
Right.
so Indigenous biodiversity is all encompassing. That covers both Indigenous vegetation and significant Indigenous vegetation.
Okay, I'll move. Right.
Okay.
Thank you. I think I've got it.
One last question that's burning in my mind as well. So if you take 50 square metres off every SNA or SIV, you could end up having a loss of 250 or more square metres of Indigenous biodiversity in every 5 years. I mean, is that...
Sorry, it's 50 square metres over 5 years. It's not 50 square metres every year for 5 years.
No, I understand that,
Yeah.
but then in 5 years, you could have taken out 250 or
No,
five.
over 5 years, 50.
But
10
each,
years,
I'm
100.
talking about each one.
You mean cumulative? I think she's.
Cumulative.
So
for each
cumulatively, there's
area.
about, I can't remember, there's about 100 sievers, right, across the district. So over 5 years, people could clear 50 square metres times 100, which is 5,000 square metres across the district.
Yes.
Yeah.
So that, you double that for 10 years and like it just, to me, it's a net loss all the time of our Indigenous biodiversity.
Andrew, do you want to answer the whole no net loss thing again?
It's not quite that simple in the maintaining Indigenous biodiversity.
Seems that
Yeah, it's because most of the areas in the district will not be cleared without a consent. There'll be these little bits, and given the area of Indigenous biodiversity, there will be, and most of it being quite young, those areas that remain will continue to develop greatly. And that's one of the key aspects in that regard. And so you will get except in areas of mature forest, which are largely restricted to QE2 covenants or, big areas, maybe at Mount Wendon or the Hokonui Hills. The rest of the Indigenous vegetation biodiversity is largely very young, and so that will just continue to develop immensely. So that's the basis that underlies that conclusion.
as long as you don't have stock taking out all the understory all the time.
Even in the, yes, that's partially true, but even in areas where you do have stock at existing levels, a lot of those areas are maintaining or they're developing from what has been observed. And yes, but there will be areas where you're right, if there's heavy stock, that may not happen.
Thank you. Thank you, Andrew.
May I now?
Yes.
You may.
Right. So that draws to a conclusion the hearing that we're having today that's looked at and yesterday at a multitude of issues. Before winding up, I really just want to talk a little bit about where to from here. So the panel has before it now the task of preparing draft decisions and then moving on to decisions. And I just want to highlight that we will be issuing a decision on each chapter of the plan. So rather than issuing a residential decision of maybe 100 and so pages long, we'll actually be breaking it up into the different residential zones and dealing with each one separately, and attaching to each of the decisions the relevant chapter of the plan. And within that relevant chapter, we will be identifying the decision point where we've made a change, the decision point that it comes from. And the majority of those in each case will be from the same chapter from. So most of the changes made to the general residential zone will be in the general residential decision, but there will also be references to decisions that have come in from other chapters, either that are consequential or are coming in from what is decision 2. Now, decision 2 is going to be looking at those submissions that have been assigned to every zone, and in some cases every chapter in the plan. So a good example is that the submissions that have come in from the Heavy Haulage Association, where they lodged 37 submissions and the summary of each one takes half a page. They will all be going together into one decision, and when you actually have the one single summary of the submission and the 18 different places it appears on each of the different zones, etc., that summary, the Appendix B, goes from 37 pages down to 1.5. So we see that as a technique of really dealing with those repetitive submissions. So from time to time we'll be going back to the consultants and actually getting a printout by submitter. So there's several other ones in terms of what's come in from Environment Southland, and in some cases that have come in from railways, where the same submission point has been lodged to every chapter. So we see that as a way of actually dealing with those, so we don't have to copy and paste the same thing many times over. And attached to each of the decisions then will be the updated plan chapter and the Appendix B relating to that chapter. As part of the updating of the plan provisions, it's relatively easy to follow for each of the reports, and relatively easy. So in some cases we've got 3 or 4 different versions that have been recommended to us, so there might be a need to clarify at some point coming back to the consultants that the version that we are using is the correct one, but I think that's relatively straightforward. What isn't straightforward is that the definitions chapter of the plan has been subject to submissions in practically most of the reports. So I just want to highlight that we will be needing the copy that I guess the consultants have been using, showing what have been their recommended changes to that chapter.
So if I can just update you, so we've been keeping a rolling copy of the definitions and the provisions. Obviously we haven't done this because we're only just going through it, but we're a long way through the plan in terms of updating what we've recommended to the whole plan.
And given that that is just minus the last few, I think it's appropriate at this stage to hand over those. Sure. And I take from what you've described is that what we're receiving is what has been presented to us in the public hearings, and there's nothing else that will be included, just so that we've dealt with that in the record. There's also a number of changes happening to the mapping, and the report that we've received, one of the reports we've received in the last week shows those, and the panel will be making changes beyond those. And I just wanted to clarify that all that data is sitting with the GIS team upstairs, or is that being held by?
Yes, I think it is. I can double check though.
The other thing is that as we've gone through the process, for example, there has been an addition recommended to one of the chapters to introduce a new Rule 5A, which means Rules 6, 7, 8 and 9, etc. Need their numbering changed with corresponding changes to the right-hand columns of the rules and all the other references. We don't see it as our role to update all of the plan provisions and cross-referencing. We see that as an administrative role that will actually come when an updated version of the plan is prepared. And I just want to pose the question publicly that that is also, from a legal perspective, the correct way to go. Shelley?
I made a brief submission on that in the legal submissions that were filed, proposing that the panel could direct for administrative changes like that to be made in their decision, and providing a proposal there. So I think that would have been circulated to anyone interested to review it as well.
Yes, so I guess as part of our letter almost that goes back to the council with our decisions, we will make provision for that the final formatting comes back to the panel in some form for signing off is probably the likely way we go, but acknowledging that there are different options available to us. And likewise,
also acknowledging that the substance of the plan itself will not change through
correct.
numbering. So
Yeah.
It is anticipated it is solely an administrative matter. So if that direction is given, then it would be carried out. And if someone identified an issue, then we would address that in due course. And there are provisions to do that, to be able to make minor corrections.
Yeah, now Matt would be able to tell us how many thousand decision points we've got to make a decision on. I guess my question is, what happens if we miss 5 out? What is the process that is followed if at the end of the process someone puts their hand up saying, I can't find my decision anywhere? What happens then?
Shelley, is it, just to clarify, does the panel have to issue a decision on every submission point, or can they do it generically, would be my question.
Sorry, can they do it?
Generically, so
The panel, as a panel, you do need to decide where you want to land in terms of a succinct decision, and I would suggest that in some cases you can be more succinct where there hasn't been a high level of debate, perhaps, and then in others that you may want to delve into particular submission points more deeply. The documents that have been provided through the process provide, a lot of analysis which will underpin any decisions which don't have that level of detail. I think this was also addressed in the original submissions in terms of how you draft your decision, so I would propose that you also go back and look at that document, which seeks to give some guidance on how to land on that perfect point of succinct but also detailed enough to show your reasoning in order to allow the parties to understand why you landed where you did.
Okay, thank you for that. And there's other administrative tasks. I think the consultant...
Sorry, can I just also tidy up the point about if you miss 5 submission points?
Yeah.
If the council was to receive correspondence identifying something was missed, we would then need to just deal with it on the day, subject to what was available at the time. If it was still within your delegation period, say, then it may be a simple referral to seek guidance from the panel. In other instances, we might need to deal with it in a slightly more complex manner.
Right, because... okay, no, I won't take that further. In terms of timing of the decisions, we've yet to work out a fixed timetable, and I think that will be an impossible task given the complexity of some of the matters that have come up in the last week, other than to note that we do have a statutory deadline of the 31st of August, and it's probably going to take several weeks of the council administration team here and the consultants actually to work out how they notify all of the submitters of the outcome of their submission points. And it may well be that an individual submitter gets decisions 2, 8, 12 and 37. But that's a matter for resolution at the council area, and one that they need to focus on rather than us. So if there's no further questions from the panel in terms of the process from here, or any other directions that either legal or planning want to give us?
I think just to note that Joe has sent through the information about highly productive land that was requested yesterday.
And can you give us the brief summary so that we're still in public?
I think, I haven't read it, but in talking to Joe, Gore has got the second highest HPL coverage in the country.
Yeah. And that was our understanding, and we were wanting the figures that supported that. So that's the key point. Yeah. All right. So that brings us then to...
Sorry, you were allowing someone to speak,
yes.
So I am going to. I just want to throw it back to Ms Chadwick, because you did signal to us yesterday that you were quite keen to touch back on your legal submissions for this hearing, and I just wanted to note that I enjoyed the opening of your legal submissions very much, and so it's just an opportunity for you to pick that up, which you signalled to us yesterday. Kia ora.
So I thought I'd go first and then allow comment from the other side of the table, as it were, and some of them are more, one's on the screen. So really the purpose of what I'm about to say is really to extend the humongous appreciation that the panel have for both the or for all of those who have had input into this hearing process. We've had a call of planners from our consultants. We've had a core of experts that have been brought in as well, and also from a legal perspective. And while at times we have not made your task easy, we see it as an important part of our process to ask those types of questions and raise issues for us to have a full understanding. We know at times that we've actually got it wrong. We know at times that it's caused a bit of frustration and a bit of work that you thought maybe isn't necessary. But from our point of view, there's that step-by-step process that we felt a need to go through to be fully understanding. And in some respects, there was an issue that was raised today where the penny only dropped now on something that was really being talked about for several months from my point of view. So to the experts that have been helping us through, we do appreciate your input. We particularly appreciate some of the dialogue that we've had by way of questioning, both in terms, I guess, of testing you, but also testing some of our own thoughts as we've gone through. To the admin team that underpins the consultants, to the admin team that underpins council here and the professional planning staff who are part of that team in terms of the role that we've had. I guess we've extended you well beyond what is expected of a council staff member, both in terms of many of the issues and things that we've asked you to do, but also the impact that we've had on your time through this process. In part, I want to express my admiration for the way that you've managed to stay calm and collective through this process when at times we've been kind of stressed out a little ourselves. Part of the admin team is also Frances and the people behind her. So thank you to you all to that. And while we're in a public meeting, I do also sincerely thank all of the submitters, particularly those who made the commitment to come along to these hearings, which probably only represents about 5% of the submitters, maybe 10% of those who lodged. And for them, we do give our recognition of the effort that they've put in, and it's sometimes wondering about questions in terms of, you know, why did they bother at times? But our questions have been, again, to identify for us what we see as the key issues. I don't think I've got anything else that I want to say, but I just welcome any other input to the panel before anyone else speaks.
I'd like to reiterate what Commissioner Hovell has said, but I also just like to say that I've enjoyed working with my fellow commissioners, although at times I know this has been quite an arduous task that I didn't quite expect, but anyway, we've got there. And I'm grateful for the expertise of the reporting officers of the property group. And Shelley, thank you. And to the staff as well for their assistance. I can say I've learned a lot through this whole process and really appreciate the opportunity. Thank you.
Yes. Well, firstly, thank you, Keith, for your input and guidance, and thank the fellow commissioners for their good humour. I'd like to reiterate the thanks and gratitude to the submitters, because this is essentially your plan, and the plan is a response to your submission, and in fact their decisions are constrained in scope by the content of your submissions. I'd like to thank the supporting staff, the planners, the expert witnesses. Goodness gracious me, absolutely impossible to sit as a commissioner without that support, and certainly it made me particularly aware of my need for support and advice. Just like to assure the public that the panel has been very very diligent and hard-working. There has been considerable debate behind the scenes amongst the panel offline, so it's not a rubber stamping exercise, and there's been an awful lot of thought put into it. I would add that the decisions of the panel are very much constrained by the RMA and what's contained in the legislation. And so the panel members, we don't have the latitude of making our own mind up on what we would like to see in there or from our own bias. And in some respects, that's both frustrating but a very good thing. So many thanks to all involved. We certainly have and will continue to try and deliver to the district the best plan that we can. Thank you.
Oh, kia ora, that's hard acts to follow, I have to say. I certainly appreciate the patience and fortitude of the combined team of consultants, administrators and legal counsel who I guess we have put through the ringer to some extent during this process, probably more than, although some of the submitters probably feel like that too. I think you're in the hot seat a lot of the time, and we really appreciate you know, that it does take some fortitude and endurance and a lot of late nights and extra effort. So we have greatly appreciated your time and effort through the process. And I guess I also want to honour those submitters who we didn't see, and as Commissioner Hovell said, you know, their voices are sitting, they haven't come along. They might be sort of 80 or 90% of those who submitted on the plan we didn't get to see in person, but their voices aren't lost in the process. We in every one of the Section 42A reports, the officers have, you know, highlighted every submitter, and in our deliberations, you know, we do a combination of looking at what the Section 42A officers have packaged up for us, and we gratefully receive, and we also look again at those voices in their original form. So I just wanted to honour those and assure everyone that nobody's voice is lost in the final analysis. So and we are looking forward to delivering a solid plan within the scope of all of those voices. So kia ora.
So I don't know if anyone else wants to say anything before I push the button for the final time.
Go, Shelley, and then I'll...
No, you go.
Okay.
Finished. Thank you all. Thank you.
Okay. So I just want to also acknowledge Ngāi Tahu and the Hokanui Rūnanga, particularly welcoming us into the Rohi and working in partnership with us and the council to develop the plan. I think that's been a really successful process. I also want to acknowledge the team at TPG, a bunch of very supportive wahine toa, as well as Brett, who you met yesterday, as well as all the experts that we've relied on too, like Andrew and a massive number of experts. We have had to put our lives on hold occasionally, particularly travelling down on a Sunday to get here for Monday hearings. And also I think we've had some pretty short Christmas breaks over the last couple of years as well to make sure we've delivered on time. I think that's probably everyone. I think everyone else has mentioned everyone. Certainly the panel for critically testing all the evidence. We did have a bit of a sweepstake on the number of minutes you were going to issue. I think we were keen for you to do 60, so it was 60 minutes, you know, a round hour kind of thing. But anyway, I think probably the time for talkies is done. and we look forward to seeing the decision in the new year. And I just wanted to do a bit of a karakia to close our side of the hearing process. So bear with me. Kua mutu a mātou mahi mo tēnei wā, manaki tia mai mātou katoa, o mātou hoa, o mātou whānau, ai ko te auranga. So that's, our work is finished for the moment, so who knows what's coming. Bless us all, our colleagues, our families, and peace in the universe. So, thank you.
Thank you. Lots of words have been spoken, lots of words have been written, and more words to be written yet. So I'll now close the hearing, and the panel will adjourn. Thank you.
Okay.